My name is Kathy Steadman. I'm a regulatory attorney in Arizona with the law firm of Coppersmith Brockelman. And I have been asked to speak with you this morning about working with agencies and staying compliant in a highly regulated industry. Of course, the industry we're talking about is adult use marijuana. One of the things I'd like to do initially is level set. These statutes and regulations are extremely dense, so no one's going to expect you to have these memorized by the time my presentation is over. But what I'd like is for you to understand that there are certain topics that are covered in the statutes and regulations so that if they come up in the context of your business, you know to go to the statutes and regulations or hire counsel or do what you need to do to ensure that you stay compliant. So you have a license, now what? So in order to obtain a license, you will have had to already determine what sort of entity that you want for operational purposes. For example, a limited liability company, a corporation, a partnership. I understand yesterday there was a corporate presentation, so you should understand all of those vehicles. But remember, in addition to the regulatory requirements for adult use marijuana, social equity applicants and licensees, there may be annual filing requirements with the Arizona Corporation Commission. So, for example, for corporations, there is an annual report requirement. So one of the most important things you can do is calendar the date of your license so that you know by that date the next year, your annual statement will be due. Because the problem is, if you have your corporate charter revoked, the vehicle that is holding the license now no longer exists, and it could create very real problems with the Department of Health Services and with the Corporation Commission. So we're here today because in 2020, a majority of voters passed Proposition 207, making adult use marijuana legal in Arizona. Once Prop 207 passed, it was converted to detailed statutes, which are found in the Arizona Revised Statutes, Title 36-2850. And then after the passage of Prop 207, the Arizona Department of Health Services, which I'll refer to commonly here as ADHS, was charged with drafting rules to add key details to the Prop 207 statutes. Those rules are found in the Arizona Administrative Code, Section R9-18-101. And you can find the current statutes and rules on the website of the Arizona Department of Health Services. So if you want to ensure that you have the most current version, that is where you would go to look for the most current version of the statutes and the most current version of the regs. ADHS. So virtually all laws that are passed in Arizona are dished to a specific regulatory agency to enforce. For example, insurance laws are dished to the Arizona Department of Insurance, tax laws are usually dished to the Arizona Department of Revenue, and so on. Because of the public health issues associated with marijuana, legal enforcement has been assigned to ADHS. They were assigned the enforcement of the medical marijuana provisions and have now been assigned to regulate adult use of marijuana. Sort of a short cartoon to demonstrate how long regulation and agencies have been around, and candidly, are you actually in a seminar if there's not at least one cheesy cartoon? So the role of ADHS. While you'll be regulated by other agencies like the Arizona Corporation Commission and the Arizona Department of Revenue, and potentially cities, towns, and localities, ADHS will be your primary regulator. As your primary regulator, ADHS is charged with ensuring that your adult use marijuana facility complies with all applicable rules and statutes. And as with most regulators, they have a tremendous amount of discretion and power when it comes to regulating marijuana licensees. So ADHS ensures compliance through a variety of means. They ensure compliance through filed complaints and related investigations. So for example, a customer may file a complaint, a neighboring business may file a complaint, a vendor may file a complaint, one of your competitors may file a complaint, and depending on the facts and specifics of those complaints, it may prompt ADHS to begin an investigation. ADHS also ensures compliance through audits and investigations unrelated to filed complaints. So because they're charged with ensuring compliance, they have investigators that may show up at your business to ensure that you are complying with the statutes, regulations, and your own policies and procedures, just to ensure day-to-day compliance. And they have express authority to penalize licensees that fail to comply with the applicable laws. But ADHS, as you can gather from these training and education sessions, wants licensees to succeed and remain compliant with applicable law. I have been dealing with regulatory agencies in Arizona for almost 30 years, and I have dealt with a number of divisions at ADHS, and it is my experience that it is a particularly open regulatory environment in that they are open to emails, telephone calls, other dialogue and conversation to ensure that you understand the statutes and regulations and that you can get through any nuances or portions that you don't understand. So they are a very open, cooperative agency, particularly the special licensing adult use marijuana folks. So if you take one thing away from this presentation today, it is that the best relationship with a regulator is a cooperative one. You are going to be dealing with ADHS as your primary regulator for so long as you are licensed and maybe even beyond. So respect, kindness, patience, and professionalism go a very long way in the licensee-regulator relationship. So compliance, where do we begin? So yesterday you went through the licensing process from representatives of ADHS. So let's assume for purposes of this presentation that you are licensed by ADHS and you have also obtained approval to operate. You have to have both. You have to obtain a license and then obtain approval to operate. So in determining how best to comply with the law, you start with the statutes. So for lack of a better description, the statutes are really the top of the food chain. It's where you begin to determine compliance of particular industries or rules. So most laws start with statutory definitions, and the adult use marijuana statutes are no different. At the beginning of the statutes are definitions, and these are the words and phrases that have special meaning in connection with the statutes. So under the adult use marijuana statutes, the Social Equity Program will issue 26 additional marijuana establishment licenses in Arizona. Those licenses will be valid for a 2-year period and then must be renewed. Again, this renewal date is very important and should be calendared immediately once the license is issued because these 26 licenses will be very valuable, and the last thing you would want is to miss your renewal date and have something happen to that license. So ADHS has the authority under certain conditions to deny, suspend, revoke, in whole or in part, any marijuana establishment license issued for violation of the applicable statutes and rules. They also have the authority to assess civil penalties against persons who violate the statutes and rules. So again, their power is broad and diverse, and they can inspect, investigate, audit, and make determinations about whether you are strictly complying, and you want to make sure that you're familiar with the statutes and regulations so that that occurs. Marijuana establishment is a defined term. So under the statutes, marijuana establishments may not deliver marijuana and marijuana products until rules are adopted by ADHS, which could be as late as January 1, 2025. So when I say delivery, I don't mean sell marijuana across the counter to a consumer. I mean a consumer calls you on the phone and request that you deliver marijuana to their home or business. The adult use marijuana statutes do not allow for delivery and won't allow for delivery until specific rules are adopted. So once delivery of marijuana and marijuana products is allowed, there will be additional statutory and regulatory requirements that apply. These requirements are intended to ensure safety and accountability of marijuana and marijuana products in transit, as those products will be delivered to consumers. The adult use marijuana statutes also governs marijuana facility agents. Again, this is a defined term, and marijuana facility agents must be registered with ADHS before working at a marijuana establishment. You should keep in mind that marijuana facility agents are much broader than just your employees. It's also your principal officers and board members, your volunteers, the owners. So this would require that the marijuana facility agents submit the required forms and pay the associated fees to ADHS, submit evidence that the applicant holds a current level 1 fingerprint card or submit full fingerprints of their own. And those marijuana facility agent cards are valid for 2 years and then subject for renewal again with ADHS. Again, important dates to calendar. In the medical marijuana laws, the dispensary agents, as they're called, fell largely to the responsibility of the dispensaries themselves. Under the adult use statutes, marijuana facility agents really have their own responsibility for managing their cards, the renewals, those sorts of things. There are marijuana establishment requirements, but the responsibility for the cards and the applications largely fall to these marijuana facility agents. Localities, cities, towns, etc., may also regulate marijuana establishments. In that regard, they may enact reasonable zoning regulations, limit the number of marijuana establishments, prohibit marijuana establishments, establish reasonable restrictions on signage, and prohibit or restrict delivery in their jurisdictions. But there are limits to what these cities, towns, and localities can do. These issues have become very, very complex of late. I think cities and towns are just starting to get their hands around adult use marijuana, figure out how they want them to operate in their jurisdiction. So it is a process that I think will have to mature over time. But the basic rule is that cities, towns, and other localities cannot regulate more strictly adult use marijuana than they have been regulating medical marijuana. So unfortunately, until this adult use, the adult use statutes and regulations season a little bit and the cities and towns figure out what they're going to do, it's likely to be a complex issue. And at some point in time, you may even need to invoke legal counsel to the extent that you collide with a city or locality over zoning or the ability to place your marijuana establishment there. So, Proposition 207 and the related statutes make it legal for a licensee to possess marijuana or marijuana products, as well as purchase, sell, or transport marijuana to or from the marijuana establishment, sell marijuana and marijuana products to consumers up to 1 ounce of marijuana in a single transaction, or 5 grams in the form of a marijuana concentrate. A marijuana establishment can also cultivate, produce, test, or process marijuana, or manufacture marijuana or marijuana products by any means. So what this means is the laws have now made it legal for adult use marijuana to be sold legally by licensees. So the worry of the Phoenix Police Department, the Tempe Police Department coming in and raiding your facility and arresting your employees and seizing your marijuana or marijuana products goes away so long as you are a proper licensee of the Arizona Department of Health Services. So this is the authority that grants you the ability to operate in that fashion. Marijuana establishments may also engage in advertising. So, in order to engage in advertising, the advertising hosting platform may host advertising only if certain conditions are met. The advertising must be authorized by a marijuana establishment. The advertising must accurately and legibly identify the marijuana establishment responsible for the content of the advertising by name, license number, or registration number, and any advertising involving direct, individualized communication or dialogue must use a method of age affirmation to verify that the recipient is 21 years of age or older. So you've probably seen the billboards, the electronic billboards. Pay attention the next time you see an advertisement or a billboard for either a marijuana establishment or medical marijuana to see if you can identify the requirements such as content of the advertising by name and license number. And with respect to the direct advertising, the individualized advertising, a lot of this is just common sense. You wouldn't show up at a skate park and hand out, direct postcards to the kids at the skate park in terms of direct individualized communication, because it would be very difficult to determine their age without requiring every one of them to get out an ID. It's just, again, common sense tells you that direct advertising should only be done in a place where individuals would be 21 or older. The adult use marijuana statutes also address packaging and restrictions on marijuana products. So marijuana establishments may not package or label marijuana or marijuana products in a false or misleading manner. They can't manufacture or sell marijuana products that resemble the form of human, animal, insect, or cartoon. And they can't sell or advertise marijuana products with names that resemble or imitate food or drink brands marketed to children or otherwise advertise marijuana or marijuana products to children. The overarching goal here is obviously to keep marijuana out of the hands of children. So, Buzz Lightyear, Sunny D, those sorts of things would be wholly inappropriate to include on packaging in order that you not entice children or people under the age of 21 to evaluate marijuana or marijuana use. The adult use marijuana statutes also address taxation. So marijuana establishments that are operated on a for-profit basis must pay taxes, including transaction privilege and use tax for a retail classification. So the way that you would address that is, and you would contact the Arizona Department of Revenue, determine what forms need to be completed, what sort of submissions need to be provided to them, and you'd also need to contact the city, town, or locality to see what sort of special sales and use tax may be required in that particular jurisdiction. So just know that taxation is an issue under the adult use marijuana statutes, and it's something that you'll need to address before you begin operations. So, as I indicated when we started, the statutes are the top of the food chain. Underneath the statutes are the rules that were developed by the Arizona Department of Health Services. And these rules are intended to supplement and fill in the blanks, if you will, in the statutes so that it really rounds out the statutes in terms of detailed information. So they provide more detail and guidance about what's allowed and prohibited as part of the adult use operations. And once again, the rules contain key definitions at the beginning of the rules and contain words and phrases that have special meaning in interpreting the rules. So It always helps. In fact, I think it's absolutely necessary to start with the definitions, make a determination about what is defined so that as you read through the rules and statutes, you understand that those particular terms are going to have a special meaning, that you may have to flip back to the definitions just to make sure that you're understanding how they're being used. So the rules also contain the details surrounding the fees that must be paid for various applications and renewal of those applications. The rules also contain the timelines and time frames that ADHS has to process certain types of licenses. For example, how long it would take to license a marijuana facility agent, how long it would take to license a marijuana establishment, how long it would take to process changes to the location of a marijuana establishment. But the key thing that you should recognize here is those time frames only begin to run when all of the forms that are required are submitted to ADHS. So in the event that there are required forms and you fail to submit all of the forms that are required, the time clock does not begin in terms of the restrictions on ADHS in terms of processing those licenses or changes. So the rules contain considerably more detail than the statutes about what documents are required for purposes of obtaining both facility agent licenses and marijuana establishment licenses. As I said, all items on the list in the rules must be submitted to ADHS, or the marijuana establishment license or marijuana facility agent license can be denied. And at a minimum, ADHS is going to ask you for supplemental information. So the reality is, it's going to slow down the process in a way that isn't favorable to anyone. It's more administrative burden for you. It's more administrative burden for the Arizona Department of Health Services. So what I generally recommend to clients is that they go through statutes and rules and create a secondary checklist. And when you're preparing your applications or licenses, you just literally go through that checklist and tick off when you have those items in your packet. And when you have every one of them in your packet, then it's time to submit. Because I guarantee you, DHS will notice if something's not there, it won't breeze past them. So, thinking that you may get by without a fingerprint card when one is required just isn't going to happen. So just make sure that the packets are complete and thorough before they're submitted. The detailed renewal requirements are also contained in the rules. So, those you're going to want to pay attention to when you're coming up on renewal for both the facility agent licenses and the marijuana establishment. Again, these 26 licenses are valuable. You want to make sure that they stay in place for a very long time. So the renewal dates are very important. A marijuana facility agent is required to keep ADHS updated about certain types of information. And again, the marijuana facility agent is responsible for this in the adult use rules, whereas under the medical rules, the dispensary was responsible for a large part of this. But under the adult use rules, a marijuana facility agent must notify ADHS in a provided format within 10 working days if any of the following information that has been previously submitted to ADHS has changed. Whether the facility agent's name has changed, whether their residential or mailing address has changed, whether their email address has changed, and the date and name or address changes when it occurred. The required fee must also be submitted with the updated or changed information. And those fees, again, are stipulated in the rules, so you would know how much needs to be submitted with these sorts of changes that are submitted to ADHS. A marijuana facility agent must notify ADHS within 48 hours after the following, and that is beginning employment or other association with a marijuana establishment or a testing facility, and ending employment or other association with a marijuana establishment or marijuana testing facility. The key here is ADHS wants to know where the facility agents are and what marijuana establishment they are connected to. So for the 48-hour requirement gives them an indication that there are changes and the facility agents may be moving around so that they can keep track of where those folks are. Also, lost, stolen, or destroyed facility agent licenses or cards must be requested from DHS within 10 days. So those cards are very important. They should be held on the person while they're in your facility. They need to be replaced very promptly in order to ensure that the facility agent is properly working and permitted to be in certain areas of your marijuana establishment. Again, if ADHS were to audit or investigate and a facility agent can produce his or her card, it could be a violation of the statutes or rules, and one that's easily avoidable if you ensure that their cards are always on them when they're working. So the licensing process was covered yesterday by the ADHS regulatory representative, so I'm not going to duplicate that information today, but just keep in mind that there are specific processes for renewal of and changes to the marijuana establishment licenses, and those processes are spelled out in detail in the rules. Administration. Oddly enough, this is my favorite part of the rules. This is when my friends tell me I should probably get out a little bit more. But under the administration, it really details what the day-to-day activities are for marijuana establishment and marijuana facility agents. And it just, from my point of view, gives you a lot more perspective about what you're supposed to be doing on a daily basis and how you get there. So it's one of the reasons why I like the administration piece in rules so much, is I think it just really guides my clients in a way that keeps them better informed about where they should be in the process. So there are a significant number of administrative requirements for marijuana establishments in the rules. And these are the types of requirements that ADHS would look for in any audit or inspection. And they are: you've got to ensure that your marijuana establishment retail site is operating at least 30 hours a week between the hours of 7 a.m. and 10 p.m. and within 18 months of receiving the license. So, as I indicated earlier, you have to be licensed and you have to be authorized to operate. What this rule is telling you is that you can't obtain a license and then just hold it and never begin operations. This rule basically says that you've got to be operating within 18 months. So it is not a license and hold situation, and the rules have addressed that. Under the adult use rules, you also have to develop, document, and implement policies and procedures regarding job descriptions, personnel duties, authority, responsibility, and qualifications, and the training of your marijuana facility agents. Keep in mind that these policies and procedures can be much more detailed than is required by the rules. And in fact, I would suggest that they should be much more detailed than is found in the rules, because you are allowed to supplement in your policies and procedures. And just like the rules fill in the blanks for the statutes, your policies and procedures can fill in the blanks in the rules to ensure that you've got sustainable and efficient operations at your marijuana establishment that everybody understands. In addition, you've got to have policies and procedures on inventory control, including tracking marijuana and marijuana products, packaging of marijuana and marijuana products, acquiring marijuana and marijuana products from a dispensary or another marijuana establishment. Remember, dispensary is the term used under the medical marijuana laws for a marijuana establishment. And you need to provide samples or have policies about providing samples of marijuana or marijuana products to a marijuana testing facility, and how you would allow a facility agent from that testing facility to access your marijuana or marijuana products to collect samples to move through the testing portion. So for social equity licensees, there are additional requirements. One is how they will establish or provide a benefit to one or more of the communities that have been disproportionately affected by the enactment of Arizona's previous marijuana laws, such as how they handle their specific hiring practices, or donation of a percentage of gross profits to one or more nonprofit community-based organizations. So just keep in mind that as a social equity applicant, there are those additional requirements that you need to think through and be prepared to include in your policies and procedures, and also execute in order to be in compliance with the adult use marijuana rules. You also have to include in your policies and procedures advertising that addresses how your marijuana establishment will comply with the applicable law. So again, you could provide more detail here than is required by the rules. Train your employees so that everyone knows the rules, but it is required to be part of your policies and procedures. You must maintain copies of your policies and procedures at your marijuana establishment retail site and be prepared to provide a copy to ADHS upon request. Again, this would be part of the investigation or audit process. They would likely come in, ask to see your policies and procedures, and determine that you are complying with the policies and procedures that you've adopted. So, my admonition is always, create the policies and procedures, A, because they're required by the rules. Make them as detailed as you need to so that all of your employees, your officers and board members, volunteers, everybody understands what the rules are, but you have to follow them. Adopting the rules and not following them is a huge problem. So when you adopt them, you really need to follow them. You also have to review your policies at least once every 12 months from the date of issue and update them as necessary. So that is the inside or the outside requirement. If you decided you needed to review the policies once every 6 months, you certainly could do so. For instance, there could be changes to the rules, other reasons why you might want to update them more often than once every 12 months. You must also ensure that all of your principal officers, board members, employees, and volunteers maintain valid facility agent licenses or cards with ADHS that are linked to your marijuana establishment. And you have to provide written notice to ADHS within 10 working days when a facility agent no longer serves as a principal agent, board member, employee, or volunteer. Again, this is the process where ADHS connects the marijuana establishments with the marijuana facility agents to ensure that they know where these folks are working or the volunteers are volunteering, and they know who has authority to be in the marijuana establishments at any given time. You also, and this again, some of this is just common sense, but you must document and report any loss or theft of marijuana or marijuana product from the retail site, cultivation site, or manufacturing site to the appropriate law enforcement agency. So if you were in Tempe, you'd call the Tempe Police Department, Phoenix Police Department. But again, if there is loss or theft, you have a regulatory requirement to report that loss or theft. You must also post certain information on the exterior of your retail site so that it can be viewed by individuals as they're entering the retail site. This particular warning deals with potential dangers to fetuses caused by smoking or ingesting marijuana, and that an individual could be reported for using marijuana during pregnancy to the Department of Child Safety. So that signage has to be up as someone enters your retail site. On the exterior of your retail site, you also have to list the hours of operation. And again, the regulations or the rules indicate that you have to operate between the hours of 7 a.m. and 10 p.m. So between those two times are when you list your hours of operation. So selling or otherwise transferring marijuana or marijuana products is also addressed in the adult use marijuana rules. This is, the consumer who comes into your retail site to buy your marijuana or marijuana products. The first thing you need to do is verify the consumer's age by specific formal means, like a valid driver's license or a passport. In the rules, it actually sends you to another set of statutes that tell you exactly what can be used as the formal means to determine whether someone is of adult age, of age 21. So you would look to those to determine what, and in fact probably put this in your policies and procedures. Here are the items you can accept as a form of proof that someone is 21 years old and viable to be in your marijuana establishment purchasing marijuana or marijuana products. You must also make available the results of testing if it is requested by the consumer. You have to ensure that the amount of the marijuana or marijuana product does not exceed that 1 ounce per visit, with not more than 5 grams being in the form of marijuana concentrate. And marijuana must be sold in a container that will not react or leach into the marijuana or marijuana product. Again, you're selling a commodity here that is largely going to be ingested in some means by consumers. So, the important part here is to package it in a way where it is not contaminated or otherwise tainted by the material that you've packaged it in. Again, common sense, but it is required. Product labeling and packaging. So if you've been to a dispensary or an adult use site, you may have seen product with a very detailed sticker on it that is part of the product labeling and packaging requirements. So your product or marijuana must be labeled with your marijuana establishment license number, the amount, strain, batch number of the marijuana or marijuana establishment, the form of the marijuana or marijuana product, the weight of the marijuana or marijuana product, the potency of the marijuana or marijuana product, an additional warning statement that is required by ADHS, and if the marijuana or marijuana product is obtained from another marijuana establishment, that needs to be noted as well as the date of manufacture, harvest, or sale. And, again, very, very importantly, upon exit from the marijuana establishment, the marijuana or marijuana product has to be placed in a child-resistant package. So that's on exit from the marijuana establishment. Analysis of marijuana or marijuana product. So these are the testing rules, and quite candidly, I believe they are the densest part of the rules in terms of complexity and the ability to understand precisely what they mean in terms of the science and the requirements. So the detailed testing and analysis is required before marijuana and marijuana products can be offered for sale. This alone, I think, could be a 2-hour seminar, maybe more, in terms of the testing and what is required. But what I'd like you to take away today is that there are specific requirements that are covered in great detail in the rules about how the marijuana and marijuana product has to be tested. And you would want to, before you begin operations, find a reputable testing facility and begin a dialogue so that you can work together to understand the testing and ensure that you are complying with the rules in terms of how often the testing is done, what the tests are revealing, and all the other requirements of the rules. Security. The adult use marijuana rules actually go into a great deal of detail about security, as you might imagine. You will be cultivating, selling, and manufacturing a very, very valuable product. So the rules are concerned with maintaining security of that product. So a marijuana establishment must ensure that if the marijuana establishment is cultivating marijuana, and if it's being cultivated inside or indoors, it has to be in a closed, locked room. if the cultivation is occurring outside, it has to be surrounded by a solid 10-foot wall that can either be concrete, metal, or stone, but you have to not be able to see through the fence to the cultivated marijuana, and the outside facility has to have a 1-inch thick metal gate. So obviously, the rules are very concerned about people who should not be permitted access to these areas where cultivation is occurring, not being able to get access, absent the appropriate facility agent card and authorization to do so. So, as you might imagine, the marijuana establishment must strictly limit persons who have access to the retail, cultivation, and manufacturing sites. From time to time, a marijuana establishment is going to have to transport marijuana or marijuana product. So the security provisions of the rules also address that. A marijuana facility agent may transport marijuana between the establishment and the marijuana establishment's cultivation or manufacturing site, another marijuana establishment, dispensary, which again is the medical marijuana term for marijuana establishment, a marijuana testing facility, and there are very specific requirements and documentation that must be completed before and during the transportation of the marijuana product. Again, the point of this is that you know in the rules that there is very specific detail with respect to transportation. I like to think of it like a flight plan. So again, the rules and Department of Health Services are concerned with security and safety. So the flight plan, if you will, addresses how to keep the marijuana product safe through that transportation process. Additional forms of security are also required to prevent unauthorized access to your marijuana establishment. So in order to prevent that unauthorized access, you've got to have security equipment to deter and prevent unauthorized entrance into limited access areas, including devices to detect unauthorized intrusion. They could be bells or dings or some sort of visual indication that someone has entered an area they're not supposed to be in. You have to have exterior lighting. You have to have electronic monitoring, including at least one 19-inch call-up monitor, printer capable of producing a still photo, so that if someone's in your establishment doing bad things, you could at least grab a still photo from your video, and video cameras that provide coverage of all of the following: your entrances, your points of sale, your grow room, and it must provide storage of those recordings for at least 30 days. You also have to have a failure notification system that provides audible and visual notification of any failure of your electronic surveillance equipment, and sufficient battery backup for video cameras to support at least 5 minutes of recording. The rules under security also require that you have panic buttons in the interior of each building. So, to deter unauthorized removal of marijuana and marijuana products, you have to have, again, policies and procedures on this type of security. So the policies and procedures need to address restricted access, ensuring that persons without a facility agent card are not allowed in secured areas unsupervised. You've got to have policies that prevent loitering around your marijuana establishment. You've got to have policies around how you conduct the electronic monitoring and the issues we just discussed about how the cameras must operate, what happens on failure, those sorts of things. And you have to have security policies and procedures that address the proper use of the panic buttons. The adult use rules then take you to edible food products, so the manufacturing portion. And you should know that the edible food product portion requires a separate license or permit as a food establishment. So in addition to the Corporation Commission, the Department of Revenue, cities, towns, and localities, and the Department of Health Services, it is typically the county health department that would issue you a food establishment permit in order to prepare the edible food product. Again, you know, you're selling a commodity that is largely going to be ingested by consumers, so it's very important that, that you maintain food grade sanitation, cleanliness, etc. So in addition, the edible food products cannot contain more THC than 10 milligrams per serving or 100 milligrams per package. And if it is packaged for more than one serving, it has to be scored or otherwise delineated into standard serving sizes and of homogeneous consistency to ensure uniform disbursement of the THC. So the example is if you have a chocolate bar that is scored into 5 pieces, one of the pieces can't have 40 milligrams of THC and the rest divided among the other 4 pieces. It's got to be uniformly distributed in order for those measurements to apply and to be compliant with those. The rules then, again, take us to cleaning and sanitation. The importance being, you know, again, the commodity you're selling is going to be ingested largely by consumers. So a marijuana establishment must ensure that its facilities are clean and sanitary. They've got to be protected from flies, dust, dirt, and all other contamination. Your refuse or waste must be taken out at least once every 24 hours. All of your trucks, trays, buckets, racks, shelves, etc., anything you're using to prepare the marijuana or marijuana products needs to be cleaned daily. Any equipment used in the preparation of the marijuana or marijuana products has to be clean and in good repair. And any supplies used in the preparation of marijuana or marijuana products has to be stored in a manner to avoid any hazardous conditions or outcomes. All of your marijuana products must also be securely covered. In addition to the cleanliness and sanitation of your facility, the facility agents must also maintain sanitation and cleanliness. Facility agents must properly clean their hands when dealing with marijuana or marijuana products. If they're dealing with marijuana or marijuana products without gloves, for example, they can't use fingernail polish. Again, you don't want contaminants to end up in the marijuana or marijuana product. They are required to wear protective apparel such as coats, aprons, gowns, and gloves to prevent that contamination. And they need to be wearing clean clothes as appropriate for their assigned tasks. And, you know, this is, I think, particularly important given the situation we're in now, but if the facility agent has a health condition that could affect the safety and quality of products, you must prohibit him or her from direct contact until the condition will no longer adversely affect the marijuana or marijuana product. So you just have to keep them away from marijuana or marijuana product until whatever condition that is clears. Your physical plant must also be free from hazards. I mean, this is more of a general, you know, slip and fall, tripping, you know, where consumers are going to come in and purchase their marijuana or marijuana products needs to be a safe environment that's free from hazards. You've got to also provide on-site parking or parking that is adjacent to the building. Again, that's for a variety of purposes, not the least of which is safety. You wouldn't want folks required to carry marijuana and marijuana products several blocks, particularly if you're operating after dark. You must have at least one toilet, toilet tissue, sink with running water, soap, paper towels, single-use paper towels in a mounted dispenser. You got to have at least one sink that's not in the toilet room. You have to have a designated area for storage of marijuana separate from toxic or flammable materials. And if preparation is done in the building, a designated area for that preparation and package has to be set up so that the workspace can be sanitized between each preparation, and it is only used for the preparation or packaging of marijuana, and there are specific requirements for the commercial devices that are used at retail, cultivation, and manufacturing sites. So, in conclusion, I again want to stress this was really an overview of the applicable adult use marijuana statutes and regulations and the policies and procedures that you are required to draft to supplement those. The key to this presentation from my perspective is that as you begin operating, you recall that certain activities are covered by a statute or rule, and it prompts you to review the statutes and rules for strict compliance. No one memorizes the rules, not even regulatory attorneys. When we know that there is an issue that comes up, for example, with respect to advertising, we go to that section of the statutes and rules, read it in light of the facts and circumstances involved, and make a determination. So that would be what you would do in the operation of your business and if you were contacting a lawyer. So just know that these subjects that we've covered are in the rules and statutes so that you can resort to them as needed in the operation of your business. The other key takeaway is the regulator is not an enemy and not acrimonious. They can be your biggest ally in terms of compliance, and maintaining a cooperative attitude and a professional demeanor with the regulators will really solidify a strong relationship. The other point is you will always want to be direct and honest with the regulator. It's important that they trust what you say. It makes the process go far more efficiently. It makes your applications move more smoothly. It makes your questions be answered more directly. But that's what I would suggest are the two takeaways today. And most of all, I appreciate your time and attention. And thanks for zooming in.